Namaste. Good morning to all. We are today conducting 93rd episode of AAA weekly webinar series. The subject today is fraudulent transactions and the fraudulent and wrongful trading transactions under section 66 of IBC. Why this subject was chosen? Because all those applications, even those applications which were filed in 2018 or even 2017 are now coming up for hearing. And now most of the benches, NCLT benches, are very, very active in taking up the buffet transactions. Many people call it buffet transaction, but in this communication today, we will use the same word. It has been used in the code and the regulation, that is avoidance transaction or avoidable transactions. So the transactions which are avoidance transactions or avoidable transactions are covered in section 43, section 45, section 49, section 50, and section 66. So these are the transactions which are collectively called as buffet transactions or avoidable transactions. The background of the entire avoidance transaction, it actually comes from UK Insolvency Act, because see, that is something that is also being used while drafting the Indian insolvency law. So this provision was required. Why it was required? That there is a tendency that when the insiders, when I say insiders, that includes the promoters, shareholders, directors, managers, they are all insiders. So in case the insiders know that now it is very difficult to save the company from insolvency, then they can do some transactions which are fraudulent with the intent and in the nature. So therefore, this particular transactions, it started its background in UK insolvency law, and in their law, section 213 and 214 was inserted, and 213 was basically for all transactions where the intent is to defraud the creditors or any other person. And in section 213, insiders and outsiders who are involved in the fraudulent transactions can be asked to contribute, to the corporate debtor. Now, today's scenario, when it is said that it is to be contributed back to the corporate debtor, that means it will go to the creditors in most of the cases. However, in some cases, the successful resolution applicant also can become beneficiary in case the resolution plan says so. However, in most of the resolution plan in India, it is very well clearly stated that any proceeds of avoidance transactions will be distributed to the creditors and not to the successful resolution applicant. So like the UK is all okay, then of course we also can see the background in section 339, 340 and 341 of the Companies Act 2013. Similar provisions was also there in the Companies Act, but then we now can see what exactly we have in section 66. Section 66 has two parts. Section 66 has two parts. One is the section 66 subsection 1. So in subsection 1, we have to see carefully what it says, that during CIRP or in liquidation process, what we have to find? We have to find that the business of the corporate debtor has been carried on with the intent to defraud creditors of the corporate debtor. So the first, it says that the business of the corporate debtor has been carried on with the intent to defraud the creditors, or for any fraudulent purposes. So any fraudulent purposes or defraud the creditors. These are the two parts which are covered in section 66 subsection 1. Then in that case, the adjudicating authority may, on an application of the resolution professional, now it is mentioned here only resolution professional, but in the beginning it is also mentioned in the liquidation process. That means that we can also assume that the liquidator can also file this application. On an application of the resolution professional, pass an order that any persons, very clearly it is written, any persons who were knowingly parties to the carrying on of the business in such manner shall be liable to make such contributions to the assets of the corporate debtor as it may deem fit. Assets of the corporate debtor, however, as per the resolution plan, this money will go to creditors most of the cases, or in case of liquidation, it will be distributed as per section 53. Now, the word used here is any persons. That actually means that this particular section 66 subsection 1, the contributions, the directions can be given to contribute the loss caused to the corporate debtor back to the corporate debtor. And that can be, the directions can be given to the insiders, that means shareholders, directors, managers, or even the employees. In this case, any persons, like any other person who actually has got some benefit out of these transactions, who was fully involved into the transactions, they also can be asked to contribute. We will come to the various examples, but the subsection 1 and subsection 2 has to be seen very carefully. So we have completed subsection 1, where the intent is important. First of all, the intent to defraud. So it becomes the duty of the liquidator, duty of the RP to prove intent to defraud the creditors or any fraudulent purposes. In such cases, any persons can be asked to contribute, means insiders as well as outsiders. Both can be asked to contribute to the corporate debtor. To the corporate debtor means finally it may go to creditors. Now, see, like in this, we have to see in the subsection 1, we have to prove the dishonest intention. So that is very, very important, that at the time when the transaction was being done, it was very clearly believed by the doers that this is a incorrect transaction, this is a fraudulent transaction, and it is being done with their clash of interest, with their personal gains. So the dishonesty should be at the time of the transaction. Dishonesty has to be proved by the RP or by the liquidator. The dishonest and the intention to defraud should be at the time of the transaction. This is the number 1. The secondly, as we said, the liability of the any persons. So therefore, this particular section is applicable to outsiders as well as insiders, like I said, employee, director, partners. Then this section will, the adjudicating authority will actually put an obligation and a liability on the insiders and outsiders to contribute to the corporate debtor. Now, although in section 66(1) as well as section 66(2), the question that may be coming in your mind is that since we are reading the section, we also should talk about the look-back period. So there is no mention of look-back period in section 66(1) or section 66(2) or section 66(3). There is no look-back period in this section. So why it is so? Normally the maxim that we say is that the once a fraud is always a fraud. Fraud vitiates every transaction into which it enters. Also, that the wrongdoers, they cannot take the advantage of just lapse of time, and therefore there is no look-back period as mentioned in the section. No part of this section. Then we move on to subsection 2 of section 66. When we carefully read this, again, it is said that on an application made by RP, however, the RP or the liquidator both can make, because where the starting of this section starts with the application during the CIRP or liquidation process. So if it is a liquidation process, then the liquidator will file the application. The adjudicating authority may by order direct that a director or a partner of the corporate debtor, as the case may be, shall be liable to make such contribution to the assets of the corporate debtor as it may deem fit if now there are two circumstances under which orders can be passed by adjudicating authority under subsection 2. One, there is a condition 1. The condition 1 is before the insolvency commencement date, such director or partner knew or ought to have known that there was no reasonable prospect of avoiding the commencement of CIRP in respect of such corporate debtors. So the first threshold is that we have to cross that threshold, that the director, I'm not saying director or partner for the sake of convenience, I'm saying the director or the management of the company had known that there are no reasonable prospects of avoiding CIRP. That is the first threshold that we have to conclude. So in case the transaction has taken place when everything was absolutely fine, when there was no stress, when there was no NPA, when there was no litigation going on and the company was healthy, if the transaction was happening, if a transaction has happened at that time, that means the first threshold is not crossed. So if a transaction has happened 3 years before the commencement date and before 3 years, there was absolutely fine, the company was not having any problem, no NPA, no default. That means that the directors probably had no thought, no belief that the company go into CIRP. So that threshold is not crossed. And in case they do some transaction without any, and now once this threshold is crossed, then we are coming to the second part. Such director did not exercise due diligence in minimizing the potential loss to the creditors of the corporate debt. When the company was healthy, no NPA, no default, any action done by the directors is protected under subsection 2. When the company is in default, NPA, the financial position is bad, the asset liability mismatch or fund flow mismatch, so it was believed by the directors that the company will go into insolvency. Then they are supposed to do due diligence in every transaction. They have to be more diligent. They have to make all possible attempts to minimize the loss of the company so that they cannot lose that diligence at this particular period, because in case they lose due diligence, that actually can tantamount to fraud. So therefore, first the threshold that we have to cross is the company was under stress. It was believed by the director that this company will go into insolvency. And the second is that did not exercise due diligence in doing the transactions of the business. So this is the subsection 2. And now when we say that the due diligence is the primary duty of the directors during this period. Now, in this period itself, this concept of twilight zone came into appearance, and that actually started from the Honorable Supreme Court judgment in the case of Anuj Jain in February 2020. In that judgment, for the first time, this twilight zone was mentioned in the IBC application. However, the twilight zone is a very, very old concept internationally, as well as even under the Companies Act also, it was very important. Now, the duty of the directors or the management is that they have to be very, very diligent while doing the transaction. They have to look into the interest of the stakeholders. They cannot do the business negligently. They cannot do the business recklessly. So that is the duty of the directors during the twilight zone. Now, the twilight zone is something. So, like again, before I go to the twilight zone, I would like to again say that when we talk about section 66(1), that we mean fraudulent trading. Fraudulent trading. And when we go to section 66(2), we can call it wrongful trading. So fraudulent transaction 66(1), wrongful trading 66(2). So therefore, in many cases, we see that the fraudulent transactions and wrongful trading, that actually means that section 66(1) and 66(2), that is what is, see, now this particular section does not use the word other persons. It only says directors or partners. That means that this particular section is only and only for insiders. It is not possible that any outsider who is not part of the management can also be asked to contribute the loss caused by the corporate debtor or any other stakeholder. So therefore, the section 66(1) for fraudulent transactions, the insiders and outsiders both can be directed to contribute. And also that particular section is also having a fraudulent intent. Once that section is having fraudulent intent, that also means that the prosecution under section 69 would also be launched in case of an order passed under section 66(1). However, in case the order is passed under section 66(2), that is a civil liability. That is not a criminal liability, because that's only because of the lack of due diligence, recklessness, negligence. But that is not, that's a civil liability. That's not a criminal liability. Section 66(1) is also having a one, that it is applicable to insiders as well as outsiders. 2, it is also criminal in nature. 3, it has a fraudulent intent. Section 66(2) is only about insiders. It is only about due diligence. It is only about wrongful trading, and it is a civil liability, and no prosecution can be launched in case the allegation is wrongful trading and not fraudulent transactions. So this is actually very, very clear. Section 66(1) and 66(2) difference has to be there whenever we are analyzing a transaction as an RP, as a liquidator, as an advocate. We have to, as a forensic auditor, we should be very, very clear that the transaction falls in section 66(1) or section 66(2). Now, see, Ankit, like, let us try to understand the section 66(2). It is very important that the transaction must happen. Wrongful trading must happen during the twilight zone. Now, the twilight zone, when we see this, even section 66(2), it says before the insolvency commencement date, that means that the insolvency has not started. When a director knew or ought to have known that there was no reasonable prospects of avoiding the commencement of the corporate insolvency process, that means the belief has now, their belief is firm that the company will go to insolvency. Then at that time, in case they are doing reckless trading or they are doing without any due diligence, they are not trying to minimize the losses, those are the transactions which are considered to be transactions during twilight zone. Now, in general parlance, twilight zone is when the sun is almost close to setting, sun is going to set, it is almost set, but there is still some kind of light before the sun becomes invisible and before it becomes completely dark. So that period when the sun is set and the darkness is not yet full, there is still a light. So that particular period is considered as twilight. So this is what is the twilight zone, and it has not been defined anywhere, but then we can say in common business parlance, refer to the period of trading when the company has insufficient funds to pay its debt and on a verge of insolvency. So that period, we have to first of all establish that when the twilight period started and when the directors believed that the insolvency is going to start, and when they started doing the transactions without due diligence, and they did not bother to control the loss of the corporate debtor. So that zone has to be found in section 66(2). However, there is no look back period. We can even go back to 7 years back. We can go back to any kind of extent. The only thing that we have to prove is in section 66(2) that the twilight zone started in 2012. Why we can say that? We can say that in 2012, the company went to BIFR. We can also say that in 2012, the company accounts were NPA. We can also say that the company was in default. So the company was in BIFR in 2012 or even before, and later on it shifted to insolvency. So that means any transaction done even during the BIFR period, or even that was also considered to be within the twilight zone, because probably the belief was firm that the company will go into insolvency. So then when we talk about this going to the section 66(3), that is only a kind of one exception, that in case the CIRP is suspended because of section 10 capital A, because of the exclusion of COVID period, in that case, no application will be filed under section 66. So therefore, the due diligence, again, explanation is given that when we call about due diligence, the diligence is whatever is reasonably expected from a person. That is what is due diligence. So Ankit, this is where we are as of now. So section 66, we can definitely now have any questions in case there are. So see, very clearly, two parts of section 66 has to be seen: section 66(1), section 66(2). There is no need to repeat, but I can still say 66(1) is for insiders and outsider, both. 66(1), we need to prove intent, and that is the obligation. That is the obligation on the applicant, and applicant is RP or the liquidator. So the intent, proving wrong intent, fraudulent intent, is the duty of the applicant. Then the contributions can be directed to be made, and this particular section is also criminal. Coming to section 66(2), that has to be during twilight zone. The transactions of without due diligence, reckless transactions, unreasonable transactions would be covered, and that's a civil liability. No look back period for both the parts of the section 66. So if there are any questions that we can take up.
So we have a question from, not sure the name of the person here. So the question says, the law says the RPA has to frame an opinion within T+105 days to file a PUF application. Then how can you say that the liquidator can move with the section 66 application unless the CD is directly taken into liquidation? So I believe here the idea is that the timeline, the target timeline of T+105 days is of course applicable during the CIRP, but we have judgments because there were a few, I think, promoters who took the plea to the court, to NCLT and NCLAT, that since the application has been filed after 105 days, it is infructuous. So there, I believe the order, there are various jurisprudence or various orders from NCLT and NCLAT which say that this is only directory, this timeline. So I believe that's why even after liquidation, the process can continue with respect to identification of PUF applications.
Of course, of course. Even the liquidator can file applications. The timeline given in section 35, regulation 35 capital A has been held to be directory. The NCLAT has said that this benefit of any lapse cannot be given to the accused. However, in case there is any lapse in the timeline, the IBPI will look into this, whether it is because of some reasons or it is because of some laxity. So it was held that in case the promoters are not providing information, in case the information came late, in case the transactional auditor could not give the audit report. So all these reasons, when it was given before NCLAT said, even if the reasons are not there, the benefit cannot be given to the accused. Benefit cannot be given to those people who are involved in the fraudulent transactions or undervalued transactions or preferential transactions. But the lapse of or the like kind of crossing the timeline, that would be seen by the IBPI separately. We'll come to that judgment also.
The second question is with respect to the update on Venus Recruiters case in Supreme Court. That's a query.
Like Ankit, in the last Saturday, we actually said that the Venus Recruiter judgment, in fact, were given to a larger bench, and the larger bench said very clearly that the single bench judgment of Venus Recruiter is not correct. So the RP can continue to proceed. The RP, when the RP becomes liquidator, still he can continue to proceed. So the benefit cannot be extended to the those accused. So the Venus Recruiter is now completely not relied upon.
Then there is a question that does this cover transaction with unsecured financial creditors? CD and unsecured financial creditors have inflated their claims by entering can I cover the same in fraudulent transactions to defraud the bank? So in case one says that, okay, I had an interaction with an unsecured financial creditor and maybe that's a related party, and that related party, what can be the possible allegations here? One possibility is that you have paid that person in priority to other people. That is covered with the that's covered as a preferential transaction, the avoidance transaction. But in case you say assign that loan to somebody and try to file a claim with respect to that borrowing that is available with the company, rather, you kind of so in that case, I believe there are various judgments where the claims are supposed to be rejected, or rather, they're supposed to be treated as related party claims. So that is how this is taken care of already. There is no loss to the creditors on account of this claim coming in and this claim being classified as a related party claim.
So you're right, Ankit, very right. So the courts have, in fact, the Supreme Court has also said how the related party transaction would be identified. One, that the related party transactions would be considered as a related party transaction as on the date of the transaction. If as on the date of the transaction, the relationship is related to each other, then that particular transaction will continue to be a related party transaction, even if it is assigned later on to an unrelated party. So that transaction will continue to be a related party transaction, and the related party would not get the benefit. One more very, very important part that I would like to discuss with my audience here is the section 67 of the IBC. One that I have not seen any judgment on section 67. I only can say, like, let us read this section 67 carefully, and this particular section is exactly the answer of this question that Ankit, you are coming. So section 66(7) in fact says, where the adjudicating authority passes an order under subsection 1 or subsection 2 of section 66. So the first is, then wherever there is an order passed by adjudicating authority under subsection 1 or 2 of section 66, it may give such further directions as it may deem appropriate for giving effect to the order. And in particular, the adjudicating authority may provide for the liability of any person under the order to be a charge on any debt or obligation due from the CD. So this is very important. In case we file an application under section 66, 1 or 2 against directors, then we can say that in the same application, we can say as a prayer that these directors or their other associate companies, they have also filed their claim in the company as a creditor. So the company is having some obligation due. They have some, the corporate debtor is having some obligation with them. So that particular obligation would be considered as something which is a charge on that liability. Now, I have filed an application claiming that the promoters have caused a loss of, say, 100 crores. In the meantime, the promoters and their associate concerns have filed their claim of about 50 crores in the corporate debtor. Then the adjudicating authority, on a prayer from the applicant, provide for the liability. We can always say that since there is an application pending, so therefore the claim of the directors, claim of the associate companies, those can be, there will be charge would be on those claims. So this is something very important, that the promoters cannot claim their money back till the time their application is pending. So we should actually say, although somebody can say that since there is no order passed so far, the section 67 only comes when the order is passed, but then we can make a request, we can make a prayer that the claim of the promoters from the company, that should be kept in abeyance till the time the disposal of section 66 or section 43 or section 45 applications disposed of. That is very well doable, and this can be given. This prayer will be given by the adjudicating authority, that the claim of the promoters or associate companies should be kept in abeyance till the orders are passed under avoidance transactions. Because it is written in section 67, provide for the liability of any person under the order to be a charge on any debt or obligation due from the CD to him, or on any mortgage. Now the second part says, Ankit, the second part says, or on any mortgage or charge or any interest in a mortgage or charge on the assets of the corporate debtor held by or vested in him. Now, in case any of the assets of the promoters, any of the assets of the promoters are with the corporate debtor, any of the assets of the promoters are with the corporate debtor, and we are expecting an order to be passed against them, so we should actually file a prayer that this asset, there should be a lien, or there should be a mortgage, or there should be a charge on this asset, or handing over these assets back to the promoters should be kept in abeyance till the disposal of the avoidance transaction applications. So, and then second is the second part of the section 66 says that from time to time make such further directions as may be necessary for enforcing any charge imposed under this section. So this section can be used, one, for keeping the claim of the promoters or associate companies in abeyance. Second, even if there are some assets of the promoters or associate companies which are with the company, so handing over those assets would also be kept in abeyance till the disposal of avoidance transaction applications. So I can see a case wherein in all avoidance transaction applications, we should also make this prayer that if there is any asset of the promoters with the corporate debtor, that asset will continue to be with the corporate debtor till the disposal of these applications. That's a prayer. Interim relief can be sought. Similarly, the interim relief can be sought that their claims would not be settled till the time these avoidance transactions are disposed of. This is actually a very, very important. Then, so it is, see, section 67 also subsection 2 says when the adjudicating authority has passed an order under subsection 1 or 2, as the case may be, in relation to a person who is a creditor of the corporate debtor, it may by an order direct that the whole or any part of the debt owed by the corporate debtor to that person. So the adjudicating authority can also change the priority of that creditor. If there is a person against whom an order is passed under Section 66 or is likely to be passed, then the priority of that particular creditor under Section 53 can also be changed. The adjudicating authority can always pass directions that the claim of this person will be paid when all other debts will be paid. That kind of order can also be passed by the adjudicating authority under Section 67, subsection 2. So this also gets confirmed. My thought also gets confirmed, because when we go and see Section 36, subsection 4 of the code, which is regarding the liquidation estate. Section 36 is the definition of liquidation estate. Subsection 4 starts like this. The following shall not be included in the liquidation estate assets and shall not be used for recovery in the liquidation. These are excluded assets. So the clause C of this subsection says personal assets of any shareholder or partner of a corporate debtor as the corporate debtor. See, such assets, provided such assets are not held on account of avoidance transactions that may be avoided under this chapter. So even in the liquidation estate, it is mentioned that the liquidation estate will also consist of those personal assets of the shareholders or partners if those assets are held on account of avoidance transactions. So personal assets can also become part of the liquidation estate in case there is any order under Section 66, subsection 1 or 2 against those persons. The claim of the creditors can also be changed. The priority can be changed, or the claim can also be kept in abeyance. So the Section 66 applications need to be changed. I haven't seen the applications are like this, that the claim of the related parties, claim of the promoters, that should also be kept in abeyance. That should be a prayer in Section 66 applications, because it is provided in Section 67 and it is also provided in Section 36, subsection 4, that those personal assets can also become part of the liquidation estate. So this is what is, Ankit, we are trying to deal with today, that the Section 66, 1 to Section 67. So let us see in case there are any questions till now, because then we will go to the judgments.
So coming to the next question, we say that, of course, this is with respect to, I'm just taking, I'll just take a question from Mr. Tarun Solanki. It is, if such directors are prosecuted, and would criminal proceedings have any bearing on the avoidance transaction applications? I think they're separate proceedings altogether. There is no crossover between avoidance transactions under IBC and criminal proceedings whatsoever.
No, there is a Supreme Court judgment. Although Supreme Court judgment, it talks about the criminal proceedings are going on, and then the proceedings under section the avoidance transaction proceedings are also going on. So although there is no connection, the criminal proceedings can go separately, and this is a separate section. So there is, nobody can say, since the avoidance transactions applications are continuing, so therefore no criminal proceedings or can continue, or vice versa. So there is, in May 23, there is a Supreme Court judgment on this.
Then we have another question from Mr. Tarun Solanki, which is, when the directors and promoters have absconded, no substantial information is available about the transactions except for the bank statements and the ABS available in MCA. Would the directors be deemed to have relinquished their rights to be heard and defend themselves? We can't say that. So we have seen cases where 66 applications or avoidance transaction applications are filed, and later we feel that the promoters or directors, of course, appoint advocates to defend those applications, even if they have not been cooperating in the rest of the proceedings. Whenever we file such applications for avoidance transactions, I think the application must state that the directors have not provided all this information, and despite that, this avoidance transaction has been filed, so that that can always be, pleaded in the court as well.
Somehow, I have a different opinion on this. Although what you are saying is the present position of the law,
Mm.
once we are saying that on an application has to be filed by the RP or the liquidator, the court says that the applicant has to prove the fraudulent intent.
Mm.
The applicant has to prove his case. Applicant has to provide the documents. Applicant has to substantiate his allegations. Every kind of onus is now on the applicant. It is not on the respondent. Respondents will always say that the RP or the liquidator has failed to prove, has not provided any substantial document, has not corroborated with the other evidences. So it is just a doubt. So that those kind of applications are getting failed, because see, the most of the senior lawyers are appearing for the promoters, and they are arguing that the RP is not having any benefit in the court. RP is just like a normal applicant, and applicant has to prove his case. And in this case, the applicant has not been able to prove this case, whatever may be the reason. The reason may be that the information was not provided. The reason may be the auditor has not given any adverse remarks, whatever may be the reason, but the applicant has not been able to prove his case. That is what is the present belief of the court, that it is the duty of the applicant to prove his case. Yes.
Mm. So, are avoidance transactions under Section 66(1) dealt with by law enforcement agencies to trace and recover funds? No, I don't think so. Don't have any
No,
such.
they will separately deal with they will work under Prevention of Money Laundering Act. They are not working under IBC. Whenever there is a CBI, whenever there is a ED,
Yeah, their proceedings will
different action.
always
They
remain
don't work under
separate.
IBC.
Yeah. They can always, of course, always, maybe in case they are also listening to the RP and the RP says that yes, this kind of an application has been filed, that application can always be taken on record by them. Maybe the similar possibilities are there, but then nothing more than that. Uh, then Tarun Solanki ji is asking, who can initiate a criminal prosecution against the insiders and outsider involved in fraudulent transactions? The RP becomes functus officio, and the avoidance transactions can be pursued afterwards too. So does the RP have the locus to prosecute the insiders and the outsiders?
See, as I said, that as far as this application under Section 66 is concerned, or Section 43 or 45 or 49 is concerned, RP or the liquidator can file. Now, if there is a criminal intent and if there is a prosecution to be launched, then under 236, the prosecution will be launched by the Insolvency and Bankruptcy Board of India, and that would be launched before the special courts made under the Companies Act. And then the RP will simply file an application under Section 236, will provide information to IBBI, and IBBI will file prosecution. The RP has got no power to file a prosecution application again under any sections. IBBI has the power.
So Pramod ji is asking that there are two creditors of the CD, and during the twilight period, CD chose to make repayment of debt to one of the creditors, and is the transaction preferential under Section 43 or 66? So I think it's preferential transaction.
It is a
That's what
preferential
they're still
transaction
covered in.
unless it is proved that this particular transaction was a regular or normal business practice, and the normal material is coming and being paid. But we see if the both are old creditors, and one is paid and the other is not paid, and the intent of payment is not to keep the company as a going concern, then it is a preferential transaction.
Then we sometimes, even as when we are doing transaction audits for IBC cases, we come to these points where, there is no preferential transaction that has happened in the last 2 years, look back period.
Yeah.
So in those cases, we feel that there is a possibility sometimes to give it a color of a fraudulent transaction or a fraudulent trading for those transactions which are before the look back period. So there again, those transactions, when we say they are fraudulent trading, we basically say that, let's say, gave some money to us. It was our obligation under the, let's say, the sanction letter to pay first to the bank before other creditors, or before drawing the money from to the promoter companies. So then we say that that's a fraudulent activity on the bankers or on the creditors. So that is the color that we give to the transactions to cover it under 66 for those transactions which are not within the look back period.
Yeah.
Because when the transaction is within the look back period, it is easier to then claim that money from the entity to which that money is paid. So that of course becomes a preferential part, becomes a preferred part. I think we can move to other questions. There are many questions. Maybe we can spend some time on the case laws and then come back.
So the one concept that I would like to say, that even CIRP regulation 38 says that that's a mandatory contents of the resolution plan, that the one of the condition that must be there in the resolution plan, that how the avoidance transaction proceedings would be continued after the resolution plan is approved, and how the proceeds would be distributed amongst the creditor. That also has to be provided in the resolution plan. That has now been added as a mandatory contents of the resolution plan. Secondly, the second part is that the stakeholders consultation committee in a liquidation process also has the power under regulation 31 capital A, that they can decide the manner in which the proceedings in respect of the avoidance transactions shall be pursued after the closure of the liquidation proceedings, and the manner in which the proceeds, if any, from these proceedings shall be distributed. So if only the avoidance transactions are left, then the stakeholders consultation committee can say that this is the way we will deal with it, and the company can be dissolved, and the distribution would be made in such manner to the creditors. Even this regulation 37 capital A also, like not readily realizable assets that can be sold, and the buffet transactions can also be sold. In even regulation 44, in the liquidation regulation 44, we have also seen one regulation which says the liquidator shall liquidate the corporate debtor within a period of 1 year from the liquidation commencement date, notwithstanding pendency of any application for avoidance of transactions. That pendency, even if there is a pendency, the still can be, a company can be liquidated. That's very, very important. So some of the common examples of the fraudulent transactions that we can give, that the transaction with the objective of keeping the asset or the property of the company away from the creditors, manipulations in the books of accounts or other records to deceive the creditors, use of forged document or records to obtain sanction and disbursement of credit facilities, bogus exchange bills, sale bills, discounting bill, falsification in the books of account. All these are basically the common siphoning of the inventory, like submission of fake financial statements. So there are various examples like this. When we actually talk about Lookback period, it is also held in Mr. Thomas George versus 𝐝𝐸𝐸𝐻𝐿𝐸 Pillai case, where it is held that under section 66, there is no lookback period. And in the case of Aditya Kumar Tibrewal, so this Thomas George versus 𝐝𝐸𝐸𝐻𝐿𝐸 Pillai is our own case. It is a AAA case. Mr. 𝐝𝐸𝐸𝐻𝐿𝐸 Pillai is a designated partner of AAA. So in this case, it has been held that for section 66, there is no look back period, and the RP can repossess or anything, like there is no limitation of time. In another case, in the case of Aditya Kumar Tibrewal versus Om Prakash Pandey, and that's again NCLAT New Delhi judgment, where the timelines in the regulation 35A has been held as directory and not mandatory, because see, in this timeline under regulation 35A, in 75 days the opinion has to be formed, and then in 115 days the opinion that it has to be found by the RP whether some transactions have been conducted like fraudulent or not, and the application needs to be filed in 135 days. So it was said that it is considered to be regulatory and not mandatory. Then even if in some cases some proceedings are pending before any other court, like civil court or any other court, still those are different proceedings, and the transaction application is a different proceedings. Both can continue. This is a completely has no relevance to the other proceedings which are pending. That is also held by the courts. Now, because see, the Honorable Supreme Court has only given one judgment in the case of Anuj Jain, in the case of JP Infra, where the Honorable Supreme Court has said that the separate applications should be filed under Section 43, 45, and 66, because the parameters of adjudication are different, and the respondents also may be different, because for Section 43, it may be the preferential creditors, and in Section 45, it may be the beneficial transferees, and in the case of Section 66, it may be insiders and outsiders. There may be different parties, so a separate application, separate arguments. So that is what was advised in February 2020 by Honorable Supreme Court in the case of Anuj Jain. So after that, we've been filing all separate applications. Even some of the important transactions, we are filing a separate application for early adjudication, because in case we keep 10, 12 respondents, so the application never gets concluded, because the replies will never come. So there will be readings will not complete. So therefore, that causes delay. So in a recent judgment, in the case of Shri 𝐝𝐲𝐬𝐬𝐜𝐝 Trading and Investment Private Limited versus Arihant Nanavati, that is 𝐴NCLAD judgment in March 23, and it is the basic issue which was involved, whether fraud for the purpose of Section 66 of IBC would consist of debts that the debtor has no intention to repay or does not expect to be able to pay. So in this particular case, the amount was given to one 𝐵𝐲𝐬𝐬𝐜 Trading, and then it was not claimed, and finally it was written off, and the NCLT ordered, then liquidation order was passed. So in this case, the appellant, in fact, so in this case it was held, I'm not going into the detail, it was held that yes, the one beneficiary, if there is one beneficiary, so that the money is collectible from that beneficiary, and that is beneficiary is actually a fraud, that has to be assumed that it was a fraud. Then in another case called Nitin Baral, the ex-director or promoter, versus Stock Flow Express Private Limited, and the name of the liquidator is Sanjay Gupta. Again, 𝐴NCLAD New Delhi judgment, and the issue involved was whether proceedings on fraudulent transactions under Section 66 of IBC can be initiated in the absence of any transaction audit. So I have been saying again and again that in the entire code or in none of the regulations says that the RP is supposed to appoint a transactional auditor or a forensic auditor. It is the only power has been given to the RP, that the RP can appoint auditors. But then it is not mandatory to appoint auditors in case the RP is able to explain a transaction, provide the documents. There is no requirement of an auditor's report. So the 𝐴NCLAD has held that the transactions reported by RP with evidences, with the documents, and if the RP is able to prove, there is no requirement of audit. So the transactions can be held as very fraudulent in case the court is convinced about the intent. Then again, we've already said that in the case of Thomas George, the person who was basically accused for wrongdoing actually argued that the transaction was more than 5 years old. However, the Limitation Act is only for 3 years. So the court, 𝐴NCLAD Chennai, has held in this case that the limitation law is not applicable to these transactions. The transaction is unearthed, and the limitation law of 3 years is not applicable on such transactions. Then In the case of Saptrishi Nath versus Kapil Dev Taneja, the resolution professional NCLAT Delhi is actually given in judgment in September 23, and the issue involved was whether under Section 66 of the IBC erstwhile directors can be subjected to a contribution order when the former management is implicated in fraud or unlawful trading, including preferential transactions. So, erstwhile director or former management, all can be implicated. But then the only issue is that the issue is 44. Section 44 of the IBC empowers the issuance of a directions compelling any individual to make payment concerning benefits. So in this case, it was held that the transaction was preferential in nature. The beneficiary was somebody else. So only the beneficiary can be directed to pay it back to the company, unless it is held as a fraudulent transaction. But then in this case, it was held that this money can be recovered from that beneficiary and not from the promoters, because this is a Section 43 case. So then we can even talk about this in the case of Amandeep Singh Bhatia versus Vital SA, NCLAT Delhi has held finally, it was an old judgment, that yes, the NCLT has the power to restrict on the suspended directors from leaving the country. And the NCLAT said that it is not a kind of restriction under Article 21 of the Constitution of Act, because it is not restriction. It is only like saying that you need to take permission from the adjudicating authority in case you have to move out. So that is the only judgment. It is not restriction. So I think these are all Ankit, but then there are some judgment, but then the time is short, and it is something which is we can take up later. So I believe we can conclude, or we can take up some questions. Your voice is not audible.
My bad. So I have a few questions here, but I think we have already taken care of the important ones. The rest that are still unanswered, maybe we can take offline because it's already 12 o'clock. That's the difficulty here. So, and I think the important ones I've already taken care of.
All right, then I think we can conclude this Section 66. So main focus was to analyze Section 66, subsection 1 and subsection 2. And then the kind of remedies which are available in Section 67 and Section 67.1, Section 67.2, when we can say that anything which is a claim of the related parties or the promoter that can actually be kept in abeyance on an application to adjudicating authority, and also a creditor's claim in case they are creditors, that can even be have a charge. So instead of giving them the money, that actually that become part of the liquidation estate. Any asset of the promoters or the related parties, that in case it is in the with the corporate debtor, that asset also can be kept, and a charge can be created on that asset on an application to adjudicating authority. That can be tried. Yes.
All right. Thank you, everyone. Thank you so much for being part of this webinar, and looking forward to see you next week.
Thank you. Thanks a lot. There's no other this thing except it's our way of learning.